Right out of the gate, we're not dealing with a minor misunderstanding. This is a THC possession case, and the court is already setting a procedural tone. Notice how quickly they go on the record. In legal terms, that signals formality is kicked in. Everything said from here is officially recorded and can impact sentencing or negotiation.
We will go on the record, it's possession of THC.
I know, I just want to make sure he has his complaint.
We'll go on the record in the matter 26 CM 25, State of Wisconsin versus Jacob Ford. The state appears through District Attorney Kevin Schmidt in person. Mr. Ford appears in person with counsel Joel Feliski making a special appearance on his behalf here today. We're set today for an initial appearance. Is this a case that we can get an offer right now or proceed normal course?
This is one where we sent a letter offering participation in our THC diversion program.
Here's the first big turning point: diversion programs. This is basically a court saying, fix the problem and we might erase the charge. It's not a free pass. It's a structured second chance. The silence or delay in responding to this letter, that's what often pushes cases back into the normal prosecution track.
Program, but never got a response. If you completed it, we dismissed the case. Is there any interest in that?
Excellent. I'm glad to hear that, Jacob. All right. So what we're going to do here today is I'm going to schedule you for another date, just like the guy who was right before you. Okay. And so I'm going to schedule you for May 27th at 1. When you're done here, you're going to do just what that gentleman did. And you're going to go to the district attorney's office and you're going to talk to Shannon. All right. She's going to give you all the things. It's a very quick program to do, but make sure you do it right away and then you won't need to come back to court. Okay. All right. So you can come get your notice and you're free to leave. Jacob, you still on Skylight Drive? Can I get an updated address? East Cedar and Webster. And I am going to need a telephone number too. Do you have one? All right. I'll give it to you. Okay. Well, here, let's just do it. Okay. Address? Because you can or not. Because that's fine. Take that up. It automatically closes. All right. 7358 East Cedar.
Notice the pattern forming already. Multiple defendants, same courtroom, same offer structure. This is judicial efficiency in action. Courts often process these cases like a conveyor belt. Eligibility for diversion, acceptance, or straight plea negotiation. It's fast, but every decision still carries long-term consequences.
In Webster. Okay. Telephone 715-416-4099. Okay. All right. All of you are waiting for Mr. Feliski? Is that a yes? No? Who are you, sir?
Mr. Pearson, Timothy Pearson.
Timothy Pearson. Come on up. I appreciate your attire.
On my way to work.
What do you do?
Security supervisor at Danbury Casino.
Nice. Nice suit.
Thank you.
We will go on the record in the matter 26 CM 45, State of Wisconsin versus Timothy Pearson. The state appears through District Attorney Kevin Schmidt in person. Mr. Pearson appears in person without counsel. We're set for an initial appearance, but is there an offer that can be presented or are we going down normal course?
We sent a letter to the address but got no response. For this one, we have a THC diversion program where if he's interested, it would result in dismissal of the charges. Is that something you'd be interested in?
I am interested in that.
Same script that we have had for the last two people. And you want to do that? So what I'm going to do is I'm going to schedule you for that May 27 at 1 date. Okay. You're going to go talk to Shannon in the DA's office, get all the stuff, do the program as quickly as you can. And once you complete that, you do not need to come back to court on that 27th.
Okay. Perfect.
You come get your notice and you're free to leave.
Thank you, Your Honor.
Well, thank you. Who are you? And you're waiting for Mr. Feliski? Or no? All
Toner's running out, so I was just going to keep making sure that he can read it.
Why don't you come on up? Deandra Carrillo. Deandra Carrillo. We will go on the record in the matter 26 CM 40, State of Wisconsin versus Deandra Carrillo. The state appears through Assistant District Attorney.
This is where things get heavy. Every count is a separate legal threat stacking on top of each other. Revoked license, ignition interlock violation, THC possession, paraphernalia. Each one carries its own penalty ceiling. In legal strategy terms, this is what prosecutors call charge stacking, building leverage for negotiation.
District Attorney Kevin Schmidt in person. Ms. Carrillo appears in person without counsel. We're set here today in this matter for an initial appearance. Ms. Carrillo, did you receive a copy of that criminal complaint?
I don't believe so.
Mr. Schmidt will get you a copy. It has 4 charges, and I'm going to go over them with you, and then we'll see where we're going to go from there, okay?
Okay.
All right, so you see those charges.
Yes, Your Honor.
Count 1 is operating with a motor vehicle while revoked. It's alleging on or around February 13, 2026 in Burnett County, Wisconsin, while being a person whose operating privileges have been revoked pursuant to Wisconsin law, you did operate a motor vehicle on a highway during such revocation period or thereafter. And that revocation resulted from an offense that may be counted under Wisconsin law. A maximum possible penalty could be a fine of not more than $2,500 or no more than 1 year in the county jail or both. Count 2 is failure to install ignition interlock device. It alleges the same date, the same time, the same place. You failed to have an ignition interlock device installed as ordered by the court. Maximum possible penalty could be a fine of not less than $150, but no more than $600, or imprisonment not more than 6 months, or both. Count 3, possession of THC. It's alleging the same date, the same time, the same place. You knowingly possessed a controlled substance, THC. Upon conviction, you could be fined not more than $1,000 or imprisoned not more than 6 months, or both. Count 4, possession of drug paraphernalia. It's alleging the same date, the same time, the same place. You knowingly possessed, with a primary intent to use, a metal grinder and a glass smoking pipe to store and smoke a controlled substance. Upon conviction, you could be fined not more than $500 or imprisoned not more than 30 days, or both. Do you understand all of those counts?
Yes, Your Honor.
Not guilty plea will be entered on your behalf. You are entitled to a jury trial. You would be entitled to a speedy trial should you request one. Still on Eagle Feather Drive.
Yes, Your Honor.
May I get a telephone number, please?
715-471-0958.
May we send you text message notifications?
Yes, Your Honor.
Mr. Schmidt, is there an offer that can be presented?
The offer in the case would be plead to OAR and IID for the DNA surcharge on each, totaling $400.
Okay, so plead to the operating while revoked and the failing to install ignition interlock device for costs,
Yes,
and dismiss the other 2.
correct.
All
And
right.
the basis of this is it's not possible for her to get a license till at least December.
Okay, so
This moment is critical. Confusion during plea bargaining, and it's more common than people think. The defendant is essentially trying to negotiate in real time without legal training. That's why judges repeatedly ask, "Do you understand?" Because misunderstanding here can invalidate a plea later.
Sorry, I just have a quick question. I didn't know I had my license there for a minute. I paid the AODA thing in Aurora and all that, and I had my license, and I didn't know I didn't have it until I got pulled over. But I am okay with the
You
Do
want to
you-
accept that offer?
Think so, unless there's a way I don't even know how to get this thing. I'm sorry, I'm not really.
The ignition interlock device?
Yeah, I don't know who to talk to.
You would need to, and you still have to do it, even if you plead to these charges.
Yep.
Go talk to Amy at the clerk's office. She is our guru and has all of the information of all of those types of things.
Okay.
And she can tell you, and you can also get a half price application where you fill that out and I sign it and you can get it for half price, because you still need to do that. I don't know what else you need to do. It sounds like you went to Aurora and you did that. Usually there's steps after that, and it sounds like those weren't taken. So you may need to redo the Aurora thing. I'm not sure on that,
Okay.
but what you would need to do is you can either talk to the DMV, you can ask Amy, she might be able to find that out there,
Okay.
or you call Aurora and you ask them if you completed all of their steps at least. Okay. And so you're here without an attorney. Do you wish to have an attorney, or do you want to represent yourself?
I'm not sure. I don't know if should I? Do you think I should? I don't know.
I can't give you that
Okay,
advice,
sorry.
but what I can do is give you some time to think about it. Okay.
Okay.
So either you can come back and say, you know what, Judge, I accept that offer. I want to do it right now. Let's get her done. And I can go ahead and take your plea. If you say, if you want an attorney, I'm going to expect that you have at least applied for the public defender, or you have an attorney before you come to the next hearing. Okay.
Okay. Your Honor, sorry.
Do you have something else?
So for those two, it would just be 400 for both of those. I'm sorry, I don't really have a job right now. I'm just trying to go for the cheapest route. So.
And it's not going to be cheap to get your driver's license. It's
Oh no, I'm not
just
talking about.
I
I'm
know,
sorry, just the
but
fines.
Even the ignition interlock device, and I'm not sure if you said DNA surcharge only.
Yes, and part of that is because of the reason her license is suspended is she hasn't paid off the OWI fine originally from Washburn, which is like
Thank God.
$1,300.
That's why. So
Okay.
I saw your
Sorry.
words there, and your words are not
Sorry.
appropriate in court, and I know you mouthed
Yep,
them,
sorry.
but
I'm sorry. Your
that's
Honor.
me admonishing you to say, I get it and I understand. That's a lot. So it's but what you could do, and I'm not giving you legal advice. You can call Washburn County and see if you can get on a payment plan. At that time, they may be able to release your ability to get your license back, and it may be cheaper, but you're going to have to make that payment plan. Otherwise, they're not going to work with you. Okay.
Okay.
So why aren't you working?
I actually just, I don't know if I don't know what happened. I was sick and I got terminated from A&W just the other day.
Okay. So you're going to look for another job,
Yeah.
right?
Yeah.
Okay. So that's good. So you're not just sitting down doing nothing
No.
and eating bonbons and watching soap operas if they
No.
exist. Okay. So that's good. So here's the deal. I'm going to set it for a date later in time. You're going to call Washburn County and see what can happen there. You're going to talk to Amy before you leave and see about the ignition interlock device and the half price thing. All right. You're going to, I'm just going to say, and call the DMV and see if there's anything else you need to do. All right. You're going to let me know. And then if you wish to accept the offer at the next time, I'll go ahead and take your plea. And he is recommending to the court only the DNA surcharge, which is mandated. So that's 200 per. So that's 400 total. And payment plan would be fine.
Okay.
With the caveat that you probably heard or that I follow that very carefully, and I will issue a warrant if you miss a payment. Okay. And you could sit up to 6 months in jail. So this is a Mr. Schmidt. How long would you think you need to think about it and get those things done? A couple weeks?
Yes, Your Honor.
How about April?
Now we're in sentencing alternatives territory. Electronic monitoring sounds simple, but legally it's restrictive custody. You're not free with a bracelet. You're under controlled movement surveillance. One violation can escalate this from misdemeanor consequences to felony exposure. That's why the judge emphasizes pre-approval and compliance so heavily.
April 21st at 1:15. Okay?
That works, Your Honor.
April 21st at 1:15. Make sure you get all of those answers. There's a pen there if you need to write down and remember all the things that you
Yeah.
need to do. You can come up here when you're done and you'll get that date and time in a printed form. So you'll have that. Just, I want to make sure that you do all of those things so you can come back and update me, okay?
Payment. I'm sorry, do I get up or? Okay, sorry. Do you just want to sit back down?
You're free to go.
Okay.
Just go talk to Amy. Talk to Amy. Go right out there and talk to Amy. We're supposed to. I don't know where he went. He confirmed this morning he will be here at 1. And I don't know. Do I issue a warrant for the attorney and the defendant?
But he can't fish.
He's out fishing for them walleyes.
He's fishing for the walleyes. We will go on the record in the matter 21 CM 112, State of Wisconsin versus Angie Jones. The state appears through District Attorney Kevin Schmidt in person. We have Ms. Jones in person without counsel. We're set here today in this matter for...
This is one of the most serious segments so far. OWI's second offense plus resisting an officer means the court is balancing public safety with procedural fairness. The judge carefully breaks down each element because resisting charges often hinge on intent and lawful authority, two highly litigated legal concepts.
Initial appearance. This has been charged as resisting or obstructing an officer and an OWI second allegation. Ms. Jones, off the record, you stated you do not want an attorney. Is that correct?
I don't think that I need one. I think
You have every right, constitutional right, to represent yourself. So you can do that. I do have to let you know that with the resisting or obstructing, the state would have to prove on or around January 28, 2021 in Burnett County, Wisconsin, that you knowingly resisted an officer while an officer is doing an act in an official capacity and with lawful authority by failing to comply with law enforcement commands. If you were convicted of that, you could be fined up to $10,000 or imprisoned up to 9 months or both. Okay, so do you understand that part?
yes, I do.
With an OWI second, that is, it's different than in Minnesota, all right? Called DUIs over there, they're OWIs over here. The way Minnesota handles them is completely different than Wisconsin handles them. With the OWI second, that means that the state would have to prove the same date, time, and place that you were under the influence of an intoxicant, and it would be your second countable offense. That's a misdemeanor. Upon conviction, you shall be fined not less than $350, but no more than $1,100, and imprisoned not more than 5 days, but no more than 6 months. So that means this is a jail sentence of at least 5 days. All right, so do you understand that?
Yes, I do.
And so knowing that, do you wish to seek an attorney, or do you can still represent yourself?
I'd like to still represent myself.
All right. And so with these two counts, you wish to plead not guilty, correct, at this time?
At this time, yes.
Okay, not guilty pleas will be entered on your behalf at this time. You are entitled to a jury trial. You would be entitled to a speedy trial once you request, or if you request one. I have to ask you a few questions, and I'm not trying to be rude or picky or anything like this, but how old are you?
48.
Can you read, write, and do you understand the English language?
Yes, ma'am, I do.
And any mental illnesses or disorders?
No,
Anything interfering with your ability to comprehend or understand things?
no, Your Honor.
Do you understand that a lawyer goes to law school to be able to learn the law and learn how to negotiate and look for defenses, or if you don't have any defenses, and make arguments and those types of things? Do you understand that?
Yes, I do.
So do you understand that there are certain disadvantages to not having a lawyer?
I do.
Okay, I just need to ask those things to make sure. At this time, is there an offer that can be presented, Mr. Schmidt?
Yeah, one sec.
Or do you need some time to think about it?
The offer would be if she entered a plea to the OWI2, we'd DRI the resisting, we'd find the refusal to be reasonable, and we'd use the lowest guideline.
All right, so in English, you want to understand, want to know what that means, or do you understand?
If you wouldn't mind, I would
No,
appreciate that very much.
there's a lot of legal jargon, and that's why lawyers are lawyers. Sometimes legal language is even complicated for lawyers. What the offer is to plead to that OWI second charge, okay? And to dismiss and read in, so to dismiss that other charge of the resisting the officer, which is that other misdemeanor. In this case, there's an allegation that you refused.
Here's where negotiation gets tactical. Refusal cases are powerful for state because refusing tests can be treated as evidence of consciousness of guilt. But the prosecution is offering to neutralize that factor entirely, basically removing a major weapon from their own case to secure a plea.
To provide any PBT, to do field sobriety, those types of things in this. And so under Wisconsin law, a refusal could be serious. They can try you on the refusal, and that would need to go first, and then try you on the OWI second. But they are saying that right now, if you accept the offer of the OWI second, dismiss that other count, they would deem that refusal as that it was reasonable, that they're just kind of going to overlook that, and so it won't be additional things and sanctions and punishments. Okay. So that's the offer. Do you understand that?
I do.
Okay. And so I'm not going to, unless you know right now, I'm not going to ask you if you wish to accept the offer right now.
Thank you.
I can give you time to think about it. So would you like some time to think about it?
Yes, please.
Okay. Because again, the minimum here would be 5 days of jail. But with Wisconsin, there's something called good time, which means it could be down to 4 days. However, there are certain things that can be argued to the court. Even in Minnesota, you can do this, but it's at your cost to have an electronic monitor and have house arrest. All right. But you have to prepay that. It's $25 a day. It would be 4 times 25, $100. But you can't do anything but work or doctor's appointments. And that would be it, because it's house arrest. And it's GPS monitored, and it's blood and drug monitored, okay? So that's an option too. So, but you would have to argue that to the court and tell me why, all right? So how long do you want to think about whether or not you want to accept this offer? You want a couple weeks? Or do you want a month?
Not a month, no. A couple weeks would be sufficient.
All right. If you accept the offer, I will need you to be here in person. And if you accept the offer and you want to argue the electronic monitor, I'm going to need you to let the court know ahead of time that I'm going to accept the offer and I'm going to argue the electronic monitor, because it's not something that can be bing bang and you can be hooked up right away. But the court can then say, I can give you up to 45 days to report to get hooked up. But if you don't report within that time, that could be a felony escape. Okay, so I'm telling you all the things, and I know it's all overwhelming, but I have to tell you all the things. Okay?
I appreciate that.
All right. So I'm going to schedule you for April 21st at 1 o'clock. All right? April 21st at 1. Do you have a job?
Yes, I do.
Where do you work?
I currently work 2 places. One, I work for a contractor who, it's Ryan James Construction. It's a very small business, but I've been employed with him for the past 3 years. And
Is it flexible so you can come and this isn't going to quite interfere?
yes.
Okay. And your other job, it's okay too?
Yeah, yes, the other job is at a bar restaurant, but
And I'll let you know if you do accept the agreement. I'm going to tell you because I like people to know all of the things that 5 days of jail, it would be 12 months revocation of your Wisconsin driver's license. I don't know how that impacts Minnesota. You have to talk to Minnesota. And it would be $975.
Okay.
That would be the fine.
Okay.
So I just want you to know that stuff. Okay.
yes,
All right. Because you were saying the lowest guidelines, right, Mr. Schmidt?
Yes.
I did the IDIP, so that's good. That's fine. With the dollar amount?
Yes.
Okay. All right. So come get your notice and you're free to go. Okay. Just make sure you're here on that date and time.
can you give it to me one more time?
You're going to come up here and
It-
she'll
she'll
give you a
give me-
printed notice. All right.
Thank you.
She's an electronic filer? You electronic filer?
I just did that because
Oh. Is there a way to get her out of being an electronic filer? Nope, you're stuck. So that's fine. She's going to print it out and you're all good. You're good. Yes. Yep. It'll come through in your email and all those things too, but now you have it in written form. Okay. All right. And I verified your address and telephone number, right? No, let me just see because I want to make sure. Is it on Jackson Street Northeast?
Yes.
And telephone ends in 9898?
Yes.
May we send you text messages?
Yes.
Excellent. Thank you. We're all good. Who do I have in custody? I have 2 people in custody and I can't see you or hear you. Mr. Avery?
Yep.
All right. And who do I have in the other jail? Maybe they're not there yet. Nobody yet. Okay, thank you. Okay. Maybe not. I don't know. We'll see. Who are you?
I'm Darcy Dimon.
All right. Thank you. Oh, Miss Dimon, your case
Yes.
has been moved to tomorrow at 2:15, okay?
Okay, thank you.
All right, so you can just tell them it's been moved to tomorrow at 2:15.
All right, do you want me to just X out of here?
Yep, you can just, yep, or I can remove you. That's just fine too.
All right, thank you.
Is Mr. Flisky outside? Yes. Okay. Can you hear me? You
Right.
can hear me better? Oh, excellent, excellent. All right. We will go on the record in the matter 25 CM 115, State of Wisconsin versus Gerard McKee Sr. The state appears through District Attorney Kevin Schmidt in person. Mr. McKee appears in person without counsel. This is a simple simple disorderly conduct. Before we proceed, is there an offer that can be presented? He has posted, maybe not. I don't think he's posted anything.
I posted a 250.
250, you did? All right. So he has $250 posted. Is there an offer that can be presented?
The offer would be an ordinance for costs.
All right. So Mr. McKee,
This is classic courtroom bargaining at the finish line. The defendant pivots from uncertainty to strategic acceptance, turning a criminal charge into a ticket-level consequence. Judges often allow this kind of resolution because it clears dockets while still enforcing accountability.
Mr. Schmidt, the district attorney is offering you, he would amend that crime to a ticket, all right? For just a ticket. Do you wish to accept that offer? It would just be for costs and it won't be a crime.
For cost,
Yes. And
what is cost?
$250. You already have it paid.
Okay, that's fine. That would be, well, I hesitate to agree.
You're not admitting any guilt.
Okay, because I don't really feel guilty.
Well, it would be a no contest where you're not saying, I'm not guilty. I'm not admitting I'm guilty. I'm not saying, anything about the case. I'm willing to accept the responsibility of a ticket.
Okay. I would be willing to accept the forfeiture of the $250 bond and time served.
Excellent. Good negotiating. So formal motion to amend
So made.
granted. All right. No contest plea is going to be entered on your behalf. $250. Time served. You're good to go.
I thank you.
Thank you.
Should I leave these here?
Miss
Oh,
Olivia will come and
Pick
get
them
them.
up?
Mr.
Thank you.
Felicia and Mr. Avery.
Yes, Your Honor.